Hello everyone, I am Anton Dominic and I will be discussing copyright law of the Philippines. So first, let us define what copyright is. So copyright is the type of intellectual property that gives the authors of original works the sole rights and protection to their outputs. It is presented by this symbol on top, a letter C inside a circle. Copyright gives the creators of a certain work the right for their ownership and protection of their works. The law on copyright of the Philippines is the fourth part of the Republic Act number 8293 or the Intellectual Property Code of the Philippines. It is enforced through the Intellectual Property Office or IPO in coordination with the Copyright Division of the National Library. It was approved on the 6th of June 1997 and was effective immediately on the first day of January 1998. The Copyright Code of the Philippines protects literary and artistic works. Literary and artistic works are original intellectual creations in the literary and artistic domain protected from the moment of their creation. So after the creator published their literary and artistic works, it is automatically protected by copyright. Here are examples of literary and artistic works based on the Section 172.1 of the Copyright Code. Books, pamphlets, periodicals and newspapers, lectures, sermons, letters, dramatic or dramatic musical compositions, works of drawing, original ornamental designs, illustrations, maps, drawings or plastic works of a scientific or technical character, photographs, audiovisual and cinematographic works, pictorial illustrations, computer programs, and other literary, scholarly, scientific, and artistic works. Copyright also protects derivative works or dramatizations, translations, adaptations, and other alterations of literary or artistic works. For example, those movie adaptations you see on screen or streaming platforms. It also protects collection of literary, scholarly, or artistic works. Copyright grants copyright holders economic rights. So the copyright holders now has the right to carry, authorize, or prevent the following: reproduction of the work or substantial portion of the work, adaptations of the work, the first public distribution of the original and each copy of the work by sale, rentals of the work, public display of the original or copy of the work, public performance of the work. So, for example, when a performer covers a song from another singer, the copyright will not belong to the performer but the composer of the song, and other communication to the public of the work. Copyright also grants the authors moral rights based on the Section 193 of the Code. The authors of the work now has the right to require that the authorship of the works be attributed to their name or simply be named the author or the sole creator of the work, to make any alterations or changes of the work or to withhold it from publication, to object any changes to their work that could damage the image of their work and their reputation, and to restrain the use of their name with respect to any work that they did not create or in a distorted version of their work. Copyright holders can't be forced to create a work or for the publication of their work already in existence. This would be classified as a breach of contract, and the copyright holder may be held liable if ever it happened. Basically, copyright holders can't publish any works that has already been in existence. Copyright holders or authors could waive their moral rights through written means. However, they are not permitted to do so if their purpose is to use their name to damage the reputation and work of another person or give credit to something they did not make. When it comes to collective works, if an author contributes to a collective work or a compilation of many outputs, for example, movie OST containing multiple songs from other composers, the right to attribute the work to their name is considered waived unless they expressively reserve it. Moral rights of an author should last throughout their lifetime and 50 years after their death. After 50 years, their work could be placed in public domain. The name of the person tasked to observe these moral rights shall be named and be written in order to be filed to the National Library. If the person tasked to observe these moral rights fails to fulfill their obligation, the enforcement would be passed to the heir of the author. And if the heir of the author also fails to fulfill the obligation, the enforcement would be passed to the National Library. If no objections have been made during the time that a copyright holder refrains their moral rights, any alterations of their works or destruction of their works will not constitute as a violation of moral rights. Violation of moral rights can be considered as a violation of the Civil Code. Any damages recovered under the Civil Code after the passing of the author should be put in a trust account and be given to the heir of the author. In a case of the heir defaulting, or if the heir refuses to accept the trust account, the recovered amount shall belong to the government. Now let us discuss who owns the copyright of the work. So in cases of original literary and artistic works, the copyright shall belong to the author or creator of the work. In cases of joint authorship or multiple individuals contributing to a certain output, the copyright shall be given to the authors or creators of this output. However, if the work contains parts that can be separately used and the creator of these parts can be identified, then the copyright shall be given to the authors of these parts. In cases of commission works, for example, those paintings that you ask someone to create for you, the final output would belong to those who commissioned the work, but the copyright of the work would belong to the creator of the output unless they have a written agreement as to who owns the copyright. In cases of employment, the copyright shall be given to the employee if the creation of the copyrighted work was done outside of their regular duties as an employee, and to the employer if the copyrighted work is a product of the regular duties of an employee. So when your boss asks you to create something for a company, the output and the copyright of it would belong to the company and not you, even though you are the one who created it. But if you did some personal projects during your working hours, the copyright of that output would belong to you, even though you did it during your time as an employee of a company. In cases of audiovisual works, the copyright shall belong to the producer, authors of the scenario, composers, film directors, and authors of the work so adapted. In respect to letters, the copyright shall be given to the writer. For anonymous and pseudonymous works, the publisher shall be considered to represent the author and hold the copyright unless the identity or the pseudonym of the author can be identified or they choose to disclose their identity. So government works and works from government-owned or controlled corporations can't be copyrighted. However, prior approval is needed if the government works would be used to make a profit. The government is also not prevented from receiving or holding copyrights by assignment, bequest, or otherwise. Based on Section 185.1 of the Copyright Code, we could fairly use a copyrighted work only if we use it for criticism, comment, news reports, teaching, research, and similar purposes. There are a few factors to determine if we are using a copyrighted work fairly. The first is the purpose and character of the use, including whether such use is for commercial nature or for non-profit education purposes. The nature of the copyrighted work, how it is used, the amount and substantiality of the portion of the copyrighted work, so how much of the copyrighted work did we use, and the effect of the use upon the potential market or value of the copyrighted work. So there would be criminal penalties if one is proven to infringe copyrighted works. Based on Section 217 of the Copyright Code, they could be imprisoned to 1 year to 3 years plus a fine ranging from 50,000 pesos to 150,000 pesos for the first offense. For their second offense, they could be imprisoned to 3 years and 1 day to 6 years plus a fine ranging from 150,000 pesos to 500,000 pesos. For their third and subsequent offenses, they could be imprisoned for 6 years and 1 day to 9 years plus a fine ranging from 500,000 pesos to 1,500,000 pesos. In determining the number of years of imprisonment and the amount of fine, the court should consider the value of the infringed materials that the defendant has produced and the damage it has done to the copyright owner. So that was my report on the copyright law of the Philippines. I got my sources from the Republic Act number 8293 or the Intellectual Property Code of the Philippines and from the first edition Handbook on Basic Media Laws and Ethics by Alito L. Malinao. I hope you learned something from my report. Thank you for watching. God bless and goodbye.